Judiciary Civil Committee meeting, April 4th, 1990.
Order. Ask the committee secretary to please call the roll.
We have a quorum.
Quorum is present.
Senator Weinstein's recognized on Senate Bill 324.
Okay, thank you. I think this is, thank you, Mr. Chairman. This is the wrongful death bill, which you passed last year. What it does is it includes the word survivor means, well, let me just explain that in an action for wrongful death, it allows an action by the decedent's spouse or children. And that means that whereas we previously prohibited the adult children of a deceased from bringing an action, we would now permit that in this particular case. And also, we would permit the parents of a deceased adult child from bringing action for their wrongful death. We passed it out of committee last year, passed the Senate last year, and I think it died on the House calendar. Hopefully that will not be the case again this year. So I will be happy to answer any questions, although I know there are a number of people who would like to speak on it. Let me just say that this is really an issue of equity. If somebody negligently causes the death of your parents and you are an adult and you're not, you would like an opportunity to seek a redress of their wrongful death, you would want the opportunity to file that lawsuit. Under the present law, you cannot do that unless you can show that they were actually providing support for you. And in this particular case, we feel it's an issue of equity and fairness in the justice system.
Thank you. Senator Dudley, you have a question or comment on the bill?
Well, both. I'm a co-sponsor of the bill, but in reading the last section where we exclude the damages by the parents of an adult child with respect to medical malpractice, and then it goes on to limit that medical malpractice claim to certain hospitals, physicians, etc. What I'm wondering is why we don't exclude, if it deals with the exclusionary cause of action for medical malpractice, why don't we put a period there rather than attempt to laundry list? For example, I'm thinking of there's a number of other health care providers, some of whom may not work strictly in a hospital setting, but you know, there's last count I think there were about 17 groups or boards under DPR that were in the medical division, and I'm just wondering, as a matter of equity, Senator, why we wouldn't perhaps put a period after medical malpractice.
Do you have any particular group that you were thinking of?
Well, I'm thinking, I don't think podiatrists are covered by this. I don't think optometrists are excluded. I'm not sure nurses are. I'm not sure physicians' assistants are. I think there's a long list of those who, if they were participants in some activity that led to a medical malpractice case, what you might be doing in this bill is eliminating some of the defendants, but not others. And so my question, and this is something I'm sure our witnesses can address, my question simply is, why not put a period on line 11 after the statutory reference to the definition of medical malpractice claims?
Senator Weinstein?
Yeah, I think that, thank you. I think that's a good question, and I'd like to hear what some of the witnesses have to say about that, and then maybe we can fix it at any point.
All right. Well, Senator Dudley, you'll hold your request until such time as we get some information. Senator Johnson's recognized.
Mr. Chairman, if we're going to talk about that, and there is a sort of a glitch here, I would think, I'm not exactly sure what 766.106 defines as medical malpractice, but there's a difference between simple negligence and gross negligence and wanton and willful misconduct. And, you know, I don't want to exclude all these people and give them a blank check. There ought to be some standard And I don't, what's the standard say in 766106?
I'm gonna get
Want to read that, Clint?
Let's see, it's 766-106-1, paren A, it says, claim for medical malpractice means a claim arising out of the rendering of or the failure to render medical care or services, period.
Well, I just don't want to vote for somebody's failure to render medical services in a nursing home or that kind of thing as being excludable under this bill. And so I think, you know, we either define it more directly for all these people, or we change what is there, because we have too many inattentive people out there that I just don't think it's fair either way for hospitals or nursing homes to be inattentive and have an excuse for it.
Senator, I'm going to ask Mr. Jess, Paul, would you please, I know you had something to do with the writing of this bill. You've heard this discussion and our concern. One, it, as pointed out by Senator Dudley, it's a little bit strange that certain people are exempted here and not all of them, and why couldn't we end it with that? And the other questions followed up by Senator Johnson. Would you speak to that, please?
Okay, what I can tell you, Senators, this language in the last paragraph was inserted during the process last year. Last year, when the bill was originally filed, it did not include any of these exceptions. And as a result of some concerns of particularly physicians in hospitals regarding malpractice, the effect that this might have on malpractice insurance rates, this paragraph was added. Having not really focused on an amendment such as Senator Dudley was referring to, I really can't answer the question of what effect that would have, and I'm not prepared at this time to say what effect it would have. I just don't know.
I think that's a good answer. Senator Dudley?
Well, I think it's a good answer as far as it goes, but let me suggest to you that if you're excluding damages for these certain types of cases, with respect, it says, with respect to claims for medical malpractice as defined in, and you put a period, then would that not include all of these exemptions as well as any others? Wouldn't it include anyone in the world who would be a defendant in an action for medical malpractice seeking damages which are specified here?
That brings up an issue that whether or not we do, for instance, want to exclude nursing homes. So, you know, that's an issue within itself, and for you to broad brush it with a period there would just exclude everybody from all medical malpractice claims.
Well, that was Senator Johnson's question. I don't think he's had a chance to respond to yet.
Okay.
Mr. Chairman, let me ask Mr. Jess a
Senator
question.
Weinstein.
Mr. Jess, what would your opinion be regarding adding in the healthcare providers such as podiatrists, chiropractors, I don't know what other licensed healthcare provider? Nurses don't act independently. Their license doesn't allow them to make independent decisions. So I don't think that we would necessarily be interested in adding them, but certainly I could see a chiropractor or a podiatrist falling in the category.
Mm-hmm.
Normally, they don't have wrongful death suits, but it could occur.
Right, and I think that was the part of the rationale for the specific listing. Again, the entities that were listed here last year, as I recall it, were listed not because of any sense of equity. I think that there is no equitable reason that I can think of to exclude these entities, but it was simply for the reality of medical malpractice insurance rates. And I think folks such as a chiropractor, for example, I can't imagine a wrongful death case. I suppose there is a possibility of one, but a wrongful death case caused by a chiropractor is not something that occurs to me as something that would have an effect on insurance rates.
Yeah.
As to entities such as nursing homes, for example, to the extent that there are some abuses out there, perhaps it ought to be a public statement that nursing homes, for example, ought to be included, that negligence relating to them because of problems, specific problems that they may have, ought to be included within the bill.
Mr. Chairman?
Senator Dudley is
If
recognized.
I could just try to focus in a little bit more on this one particular section, we're not only talking about a class of cause of action called based on medical malpractice, as opposed to an intentional infliction, an automobile accident or whatever, but we're further, Mr. Chairman, members, talking about the element of pain and suffering only in medical malpractice cases, and then further restricting it to a class of plaintiff, being the parents of an adult child. So if my adult child is in a nursing home, for example, and is wrong, and their death is wrongfully caused by medical malpractice, I could not recover under the way this bill is written for my pain and suffering. Doesn't say I can't recover if I otherwise have a cause of action. So when I was talking about the equity issue a moment ago and suggesting the period on line 11, that only relates to damages for pain and suffering in medical malpractice cases where the plaintiff is the parent of an adult child whose death has been wrongfully caused. Very, very limited focus. Would you agree with my?
I agree with that analysis. Yes, Senator, absolutely. That is how it would work.
Why don't I suggest we work the particulars of that out before the bill gets to the floor? I think we all want to go in the same direction. Senator Weinstein, it's your bill. What do you think?
I'd like to try and pass it out if you're give the staff time. I don't think it's going to work tomorrow. Give us time to work on it. I'm sorry, the microphone wasn't on. What I said was I'd like to pass the bill out of here today. There are no other committees, but certainly if Senator Dudley, if you want to try and work up an amendment that we can work on it before it gets to the floor, I certainly would have no objection to that. I don't want to do something, spur of the moment.
Well, time kept us from passing this bill last year, as you know, and I'm sure the chairman wants to get it out here today so we don't have that problem this year. I think we had a consensus on the bill last year. We just did not have the time to get it through.
Yeah.
So
Well, passed the Senate, didn't pass the House.
didn't get out of the House because didn't get out of the Senate to the last
That's
day
why
or
the
so.
Rules Chairman is the sponsor in the House now.
Right.
Mr. Chairman, it was not my intent to offer an amendment today to a bill on which I am a prime sponsor, but simply as part of the discussion and the testimony to help lead us perhaps in a direction of making a better bill. I don't know.
Okay.
Mr. Chairman,
Senator Johnson.
I just want to say that it's our duty as a committee to make sure this bill passes out of here properly and correctly, and I'm not going to vote on a bill with the idea we're going to correct it between here and the House as the Senate floor. I'm not going to do that. I don't think that's fulfilling our responsibility, and I want a bill that I can look at and say, yeah, it's constitutional and it's judicially sound, and I'll vote on that bill.
Well, would you offer an
But I
amendment to
withdraw
clear it
as a
up?
sponsor.
Or will you offer an amendment to clear it up to your
I think,
satisfaction?
that, Senator, we're going to be here about another hour and a half. I think Senator Dudley made the exact expression. I would like to see the staff remove the references to subsection 3 and subsection 4 and put in there exactly what Senator Dudley said, that this shall not apply except, in those exact words that he put in there a while ago, and without relating back and forth to everything else, just put in here what you mean in this one paragraph, and we can vote it out of here.
Mr. Chairman,
You got 3 staff members
Okay.
here, and
what's your prerogative, Senator Weinstein?
All right, why don't we just go on to the next agenda item and see if he can come up with something.
Okay.
Do we have others who want to testify on the bill?
Yes, we have a number of
Yes,
people.
we do. Let's go ahead and take some testimony on it, then maybe that'll give you some background to combine into an amendment that can clear it up. All right, we would like to hear next from Mr. Bill Harrell.
I prefer
National Federation of Independent Businesses.
Bill Hurley, National Federation of Independent Business. We represent about 17,000 small businesses across the state. We just need to make it clear that a vote for this bill is a very bad vote for small business. We're in the midst of a workers' compensation crisis where premiums are just going through the ceiling. A lot of small businesses today, when they add up their workers' comp premiums and their health insurance premiums, their product liability, their general liability, they're paying more in premiums than they are in total payroll. And those are a lot of dollars that leave this state forever. We just also want to remind you that the Tort Reform Commission, or the Academic Task Force on Tort Reform about 4 or 5 years ago recommended against any extensions of the Wrongful Death Act, and we will be opposed to this bill.
Okay, Ms. Jody Chase. She's with Florida Chamber of Commerce.
Thank you. My name is Jody Chase, and I represent the members of the Florida Chamber of Commerce, and they've asked me to come here today and speak in opposition of this bill. I think before you do vote on this bill, you need to fully understand what the bill does. The bill will certainly do one thing, and that is cause liability insurance rates to go up. There are two factors that cause liability insurance rates to go up. That's frequency and severity. This bill contributes to both frequency of loss by opening up the doors to the class of people who can be plaintiffs, and also severity of loss by opening up the doors to the class of people who can get those very nebulous pain and suffering damages. So this bill will certainly cause liability insurance rates to rise. Well, I understand that one of the arguments in favor of this bill is that, well, it's not so bad for liability insurance rates to rise. The reason that we need this bill is because of fairness, but we could examine that as well. Business right now is paying workers' compensation insurance rates that have skyrocketed. The legislature is very diligently trying to work on that problem. They have been told that their rates could go up 75% next year. They're paying very high liability insurance rates as well. If their liability insurance rates go up on top of their workers' comp rates, we'll shut the doors, people will be out of jobs, and that's not fair. Let's look at fairness again. Is it fair that medical malpractice is exempt? I understand from Mr. Jess's comments that medical malpractice was exempt last year because of the effect on their insurance rates. If it's fair to exempt med-mal because of their insurance rates, is it fair to make business pay for this bill because of our insurance rates? We don't think so. Also, the rationale is to help people, but you have to look at that a little more closely too. The $2 million verdicts that we get, the $1 million verdicts that we get, the $900,000 verdicts that we get, a large portion of that verdict is attorney's fees. Maybe it's fair to limit attorney's fees to 2% of the recovery because the attorneys are saying that our rates will only rise by 2%. If we're going to do something fair, let's do something that's fair across the board. I think it's important to keep in mind that we will have to explain why our liability insurance rates are going up at the same time our health care costs are going up and our compensation rates are going up. So I think it's important just to keep in mind the perhaps unintended effects that this bill will have.
Mr. Chairman,
Senator Dudley.
I'd like to ask the witness this question. If you are over 25 years of age, I mean, I'm not asking your age. I realize that's not an appropriate question.
I haven't gotten near 25 yet.
If you were over 25 years of age and you were killed through the fault of someone else, could be a drunk driver, could be a bad doctor, could be whatever, and you have no spouse and no children, your parents under current law cannot sue for mental anguish that they may suffer, and I would hope they would feel some mental pain and anguish for the loss of your companionship, etc. Now, is that fair?
I cannot disagree with you, and I cannot say that that's not fair, but you also have to understand that you can't solve every ill in this world by asking business to pay. The way the law currently is written, if you're over 25 years old and you're dependent on your parents for support, or you're dependent on your child for support, if you can show that dependency, you can collect your economic damages. And that's what the Wrongful Death Act was designed to do. And the Wrongful Death Act is working well as it is now, so there's no reason to come in at this point and change it when the tort reform people recommended that we don't, and when the insurance rates are going to go up, there's really no reason to do it right now.
So if your parents had no economic dependency on you whatsoever, and you were killed through the fault of someone else, no matter how blatant it may have been, no matter how much your parents may have suffered from the loss of your companionship, whatever, you think it's fair that they should not have a cause of action, a right to sue that drunk driver or that bad doctor or whomever it may have been. Is that what your testimony is?
Well, no, sir, it's not. I don't think that that's fair. However, if I was killed by a drunk driver, there are criminal statutes. He can pay with his very liberty. Med-mal is being exempted out, so if it was by a doctor, they couldn't get pain and suffering anyway. The only thing that you're saying is if a small business owner inadvertently, due to lack of due care or negligence, causes somebody's death, then it's only that business person who's going to have to pay. And that's not fair either. And I agree that the world is not perfect, and my parents would be very upset if it happened.
That's our job.
The world isn't perfect. And if we're going to make the world perfect, then let's make it perfect across the board. And let's put everybody in the pot. Let's limit the attorney's fees and put the doctors back in the pot and make the whole, solve all the problems of the world with one bill if we can.
Senator Johnson, discourse continues.
I just tell you an exact case. A lady in my district educated her daughter at the University of Florida, put her through a master's degree program at nursing at the University of Florida, and she was killed after graduation on her way home. The mother got 0. Now, if you want to be fair, you pass the best laws you can, and you also do other things right. And I would submit to you, if you want to be fair about Florida litigation, all we need is one law that says the prevailing party gets attorney's fees and cost. That'll take care of a lot of the fairness. So you're beating the wrong drum. As a matter of fact, small business will not pay the majority of this to be paid by the automobile owners of Florida, who are causing the most wrongful deaths. And you all would be a very small participant in that whole process. But if you want to be fair, all you need is one law that says the prevailing party will receive all attorney fees and costs against the loser, and that'll be fair. That'll take care of a lot of this baloney we see out there in the courtroom today. Save you big dollars for small business.
Senator Weinstein.
Now, I have a question. Maybe, Senator Johnson, maybe you can answer this. If that woman in your district had run up loans in her name of $50,000 or $100,000 educating that daughter, would she be entitled to recover that money under the present law?
Well, many people do that, and the answer is no, she would not. She would not be entitled. She would not recover it, entitled even to sue. And as a matter of fact, that lady wrote me a letter, and I knew the lady, and she had borrowed money to educate her child. She was a poor member of the minority who worked 7 days a week to educate her kid, and she's still a poor member of the minority working 7 days a week to pay the bills.
And if she had bought her daughter a car and signed the note on the car, she wouldn't be able to recover from that?
Well, she would get the car through probate, but she still had the debt.
Okay, any other questions of this speaker? If not, thank you, ma'am. R.J. Castellanos, representing the Division of Risk Management.
Thank you, Chairman and Senators. My name is R.J. Castellanos. I'm the Director of the Division of Risk Management, and as you may know, the division operates the insurance program for the state of Florida. We handle the claims that are filed against state agencies, and those include wrongful death claims, and operate as a self-insurance program to make sure that the claim is defended and that the claim is eventually settled or paid. I'm just here basically to provide the little bit of information I have. My concern, of course, is that I am directly responsible for the Florida Casualty Trust Fund, which is the fund to which all state agencies pay their premiums, which then is used to pay claims and costs of defense and operating expenses and so forth to run our program. The Casualty Trust Fund is not in the best of shape right now. We're projected to lose probably $8 million or so more than we were able to take in. And that funding, of course, comes from, the most part of it comes from general revenue and the state agencies that obtain their premium money from general revenue to then pay into us. So basically what I'm saying is that this bill will have an effect on increasing, since it does increase the number of claims and the amount of damages that we'll have to pay for those claims, it will have the effect of increasing the expense to the state for running our risk management or insurance program. We have, and I've got a few figures here, we have 130 active wrongful death claims right now. Those are pending files. 11 of those involve medical malpractice, so if we exclude those from the total number, it comes out to about 119 files. Our reserves, or the amount that we estimate we will eventually have to pay on those claims, is approximately $4,300,000, around that number. And of those claims, 43 of them involve a situation where a spouse is a survivor and therefore a claimant, which under this statute would then not have the effect of allowing adult children to have a claim. And that's about as much information as I have. We did manually pull each file and look through it and try to tabulate the numbers, but since you're in effect attempting to open a new area or allow claimants who have not been able to file claims in the past to now be able to file claims, there's no way you can tell from our claim files how that would result. You know, the claim files don't tell you how many family members there were in a particular family. It just tells you from the complaint how many are claiming under this the wrongful death statute.
Senator Dudley had a question.
So in other words, there are claims that you have received in the past that have been rejected because the claimant was not a member of the class covered by the statute.
He didn't say that.
Well, I'm asking. Have you had cases where you've rejected the claim because the claimant was not covered by the wrongful death statute?
I honestly don't know. I would imagine that there might be a situation where an attorney out there had not read the statute carefully or had thought that, you know, they fit in that class and had included that particular person, and we brought it to their attention, moved to dismiss or whatever. But I really don't know.
Just to follow up. So then, if you're estimating that under this statute, if it were law today, that the losses would go up, that would indicate to me that there's some uncompensated parties out there right now under current law.
Yes, sir. I imagine that's what we're here for, is there are some parties that are...
Thank you. Senator Johnson's recognized.
I'm just curious, are you authorized to pay in excess of the sovereign immunity limit in your settlement of claims?
No, sir.
So you're...
That comes up to you all as a claims bill.
Then how do you get to $4.3 million for 130 active claims? You have more than one death in a claim in an active file?
No, that's our reserves for that many cases.
These are bridge tenders, raising bridges in people's faces and that kind of thing that take place. And we had one in Sarasota last week where the lady was killed with a bridge raised in her face before the gate was lowered.
That's another good point, Senator, is that this, you need to remember that this number is utilizing the state sovereign immunity, the 100,000, 200,000 limitation. It's not an unlimited.
Any other questions? Thank you, sir.
Thank you.
John Hogan Mueller, is that close enough? We've got two more. He's with Associated Industries and wants to talk about the economic impact.
I think Jody covered mainly the arguments that we had in her presentation, but we just wanted to at least go on record to the committee that on behalf of our approximately 4,000 members that we also are in opposition to this bill. Thank you.
Thank you. Okay, Mr. Ed Fortune has a bit of information. He's neither for or against the bill.
Thank you, Mr. Chairman. Senators, I share the same concern that Senator Dudley and Senator Johnson has mentioned earlier. As the bill is drafted today, I'd like to share with you the problems of equity that's in the law. You exempt a nurse who practices in a hospital. But that nurse who practices in a nursing home is not exempt under the present language. You also exempt a nursing home if they're owned by a hospital. And there are some nursing homes that's owned by hospitals. But on another freestanding nursing homes, they're not exempted under this proposed bill. So we have a real concern and a real problem with the bill as drafted as far as equity, because we believe that it is not equity. And what will happen is that we're going to see an exit of nurses, and the problem we're encountering today is having nurses in long-term care facilities will be exodus into hospitals or in other areas without being faced with this kind of liability. So I believe that it's not a good state policy to develop this kind of inequity in trying to solve an equity problem, and that's what this bill would do. So I have a real concern with this and hope that you will address that, and when you draft the amendment, that everyone will be treated equally.
Senator Weinstein has a question. Mr. Fortune, if you'll stay. Okay, thank you, Mr. Fortune. Any questions of Mr. Fortune? Senator Weinstein is recognized.
I just want to make a quick point. This is from a publication this is from the Florida Chamber, and they did a point-counterpoint on whether the legislation, the wrongful death legislation, should be allowed. And one of the points that was made from the Florida Chamber publication is the current law amounts to an artificial cutoff of rights. If you leave two children, ages 23 and 25, and neither is dependent, the younger child is automatically entitled to benefits, and the older child is not. I think that's the whole sum and substance of this issue, is that it's just artificial, arbitrary, and capricious.
Senator Plummer.
Yes, thank you, Mr. Chairman. You just said that was written by the Florida Chamber of Commerce. We just heard from the Florida Chamber of Commerce and spoke against it. I'd like to hear which way the Florida Chamber of Commerce is going.
I said, let me say that they prepared a point-counterpoint to this issue, and the point, I just said, and the point was that that it's an artificial cutoff of rights. What you heard Jody testify to was the counterpoint part of it. I was just giving you the other side of that. Right. I wanted you to have both sides of their evaluation.
What about the hospital convalescent home? That bothers me greatly. That is totally inequitable, and I think you need to address that quickly.
Well,
I think an amendment is being prepared, Senator Plummer. You weren't here earlier when we started arguing about this. An amendment's being prepared to exempt all medical mal. All right, Mr. Jess, do you care to close on the bill as far as the one in favor of it here?
I don't have a lot to add to the discussion that's gone on, except to say that this is an equitable bill, and that in reaction to some of the comments that have been made about the cost of this bill, I don't think we ought to set public policy of this state based on what the insurance rates might be. We don't believe that this will be a significant increase in anybody's insurance rates. I doubt very seriously if the passage of this bill will make any insurance company, computer, even burp. But I would also like to say that if I understand Senator Dudley's comments regarding a potential amendment to simply place a period after the statutory reference to 766.106 paren 1 in Section 8, I don't think that would be a substantial change to this bill. It would encompass some other entities that are not currently listed in there, but I don't think that would be a significant change to the purpose that we're trying to accomplish in this bill.
All right, are you saying you don't oppose that amendment? I have it before me.
That's correct. If all the amendment does is strikes the language after
all right, if you'll follow the bill, all the bill says on page 2, line 11 through 18, strike all of said lines and reinsert defined in section 766.10.106 sub 1, period. Okay, that amendment's offered by Senator Dudley. Any discussion on the amendment? Senator Weinstein.
I'm only offering it with the approval of the senator, or at least his approval for discussion. Otherwise, I do not intend to offer it.
I don't have a problem with that.
All right, Senator Weinstein says he has no problem with it. Anyone want to speak to it? The amendment says, on page 2, lines 11 through 18, strike all of said lines and insert as defined in section 766.106 sub 1. Anyone in the audience want to speak to that? That solves your problem, Mr. Fortune?
Yes.
Okay, anyone else want to speak to it? Anyone want to vote against this amendment? All right, you want to speak against it?
Yeah, just want to vote against.
All right, let's call the roll then on the vote, please. Senator Dudley moves the amendment. Roll call.
No.
Senator Davis?
No.
Senator Dudley? Senator Girardo? Senator Grant?
Yes.
Senator Johnson? Senator Margolis? Senator Plummer?
No.
Senator Stewart? Senator Gordon? Senator Langley?
No.
Chairman Weinstein?
No.
Noes have it.
Amendment fails. All right, any other amendments to offer to the
So
bill?
it's okay, I didn't mean I was going to support it.
Any other amendments?
I have one. Trying to work it out here.
Okay, we're ready to go on it.
I'd like to at least discuss, on page 1, line 28. It says minor children of the decedent and all children, if no surviving spouse. Wherever that appears, I'd like to insert all children under the age of 35.
Minor children.
We have minor children defined in the bill for all damages, but I'm talking about these limited damages are defined in this bill if they were under 35. Takes care of most people that perhaps have some kind of economic investment in their children, through education or otherwise. I don't know if you can even clean the bill up, where
This is arbitrary as 25.
problem limitations already.
You want to offer that, Senator? You want to offer it on the floor, or what do you want to do?
That's it anyway. We're gonna have,
Yep, Mr. Chairman,
Senator Weinstein.
let me just point out, Senator Johnson, you're talking about page 1, line 28 refers to minor children of the decedent recovering. Now, that's the opposite of the example you gave of the lady who had that investment in her daughter's education.
Senator Weinstein moves the bill. Any discussion on the bill? Anyone want to speak for or against it? Secretary, call the roll on the bill.
Yes.
Yes. Senator Dudley?
Yes.
Senator Girardo? Senator Grant?
Yes.
Senator Johnson? Senator Margolis? Senator Plummer? Senator Stewart? Senator Gordon? Senator Langley?
Yes.
Senator Weinstein?
Yes.
By your vote,
Have
you
it.
pass Senate Bill 324.